Rule 113 is entitled Organization as Client. It concerns attorneys for corporations or other entities such as organizations or governmental agencies. For simplicity, I will use the term corporation in this lecture. The first principle is that corporations act through their constituents, the president or vice president of the corporation, the board of directors, or other individuals within the corporation. Accordingly, the attorney must advise the relevant representative of the corporation just as he would advise an individual client. As Comment 2 notes, the attorney's communications with a constituent acting on behalf of the corporation is confidential, protected by Rule 1.6. Note, however, that this does not mean that the lawyer is representing the constituent as a client. The lawyer must maintain the confidentiality of the corporate client and may communicate confidential information to others within the corporation only to the extent necessary to carry on the representation of the corporate entity. The landmark case of Upjohn v. United States fleshes out the way in which confidentiality and privilege work in the corporate context. In that case, the company's general counsel learned that a subsidiary had made illegal payments to foreign governments. The attorney conducted an internal investigation, including interviews and questionnaires sent to employees. Then the company voluntarily reported these illegal payments to the SEC and the IRS. At that point, the IRS began its own investigation and subpoenaed the questionnaires and the attorney's notes. Upjohn protested having to turn over the questionnaires or attorney's notes. The U.S. Supreme Court found for Upjohn, holding that these documents were privileged. They were privileged because the communications concerned matters within the scope of the employee's corporate duties, and the purpose of the communications was to secure legal advice from counsel. These matters were privileged even if the communication was with a low-level employee. Any time an employee of an entity is communicating with the entity's counsel to assist the entity, that communication is confidential and privileged. Of course, this ruling didn't stop the investigation. The IRS could still interview all the same employees. It just couldn't take the shortcut of accessing the attorney's privileged work product. There may sometimes be difficulties in representing an organization through its constituents. For example, a given constituent may have interests that diverge from the interests of the corporate entity. The lawyer must be ever mindful of this possibility. If the attorney believes that a constituent does not realize when his interest may differ from the corporation's interest, the lawyer must ensure that the constituent understands this. This can occur when a constituent is asking questions about how he personally should proceed to protect his own reputation, rather than focusing on what is best for the corporation. Rule 113F rather subtly notes that the lawyer must explain the identity of the client when the organization's interests are adverse to those of the constituent with whom the lawyer is dealing. In some limited circumstances, the lawyer is obligated to go over the head of the individual with whom he is dealing for the good of the corporation. Rule 113B provides that if a lawyer knows that a constituent is making a decision or taking action that is a violation of the legal obligation to the corporate entity, or a violation of the law that might reasonably be imputed to the corporate entity and likely to result in substantial injury to the corporation, then the lawyer must proceed as necessary to promote the best interest of the corporation. What this means is that the lawyer has the obligation to go up the chain of command about the matter. Let's flesh out how this might happen. Imagine that in-house counsel is consulted by a manager who has terminated an employee. The terminated employee has written the manager a letter threatening to take legal action. During the consultation, the lawyer learns that the terminated employee has complained to the manager about another employee badgering her to date him, and the manager chose to terminate the complaining employee, who was less valuable than the badgering employee, given that they were all at-will employees. Counsel would note that the manager has probably violated his obligation to the corporation, as under corporate policy, sexual harassment cases are to be referred to the HR department. This would require going up the chain of command if the manager refuses to take corrective action. Counsel would also note that the manager has made a decision in violation of the law, terminating an employee for complaining of discrimination, and that this violation of the law would be imputed to the corporation. Whether the corporation would likely experience substantial injury is less clear. In any event, this scenario should require that the in-house counsel go over the head of the manager if counseling the manager doesn't solve the problem. Rule 113b establishes that the attorney may need to go up the chain of command to the highest authority that can act on behalf of the organization. Thus, the lawyer might go over the manager, to the director of HR, to the vice president, over the manager, and then over the head of the vice president to the president, or even to the board of directors. The board of directors is typically the final decision maker, the highest authority that can act on behalf of the organization. In even more unusual circumstances, the lawyer for the corporation is able to go to an outside entity, say a governmental regulator such as the SEC or the FDA. For example, if the highest decision maker for the corporation is deciding to do something that violates the law and will put the corporation's interest at serious risk, going outside the corporation may be permissible. Rule 113c deals with the situation when the highest authority refuses to address corporation action that is clearly a violation of the law and the violation is reasonably certain to result in substantial injury to the corporation. Then, the lawyer may reveal information to prevent substantial injury to the organization. This is true whether or not Rule 1.6 would permit such disclosure. But the attorney may reveal this information only to the extent reasonably necessary to prevent substantial injury to the organization. Imagine that counsel has learned that the corporation has discharged toxic waste in a waterway and has failed to report it, both violations of the law. Despite the lawyer's urging, the CEO and the board of directors refuse to make the required reports. The attorney knows that once the harmful effects of the discharge are noticed, everyone will attribute them to the client corporation. In this case, the attorney would be justified in going to the governmental agency itself and informing the agency of the discharges. Note that this whistleblowing is justified only to the extent necessary to prevent injury to the corporation. The lawyer is not entitled to go to the news media if going to the governmental regulator would suffice. Rule 113d clarifies that these whistleblowing rights and responsibilities of lawyers do not apply to the attorney retained to help the corporate client deal with the alleged wrongdoing. Rule 113e deals with the attorney who has been fired because she is doing the right thing. If the lawyer has taken actions described in paragraphs B or C above, she should proceed to ensure that the corporation's highest authority knows of her dismissal or withdrawal. The final section of Rule 113, Section G, deals with the possibility of corporate counsel representing not only the entity, but also individual constituents of the entity. This typically occurs when a corporation is sued and individuals within the corporation are named in the suit as well. Corporate counsel may be permitted to represent both the corporation and the individual named defendants, provided there is no conflict of interest between the corporation and the individuals. Conflicts of interest will be the topic of the next unit. This section establishes that the corporation's consent to dual representation must be given by an appropriate corporate official and not by the individual who also seeks representation. This concludes this unit. Thank you.